Tonight, let's hear from the PDP lawyer, Mr. Emeka Etiaba. He joins us from London. Thank you so much, Senior Advocate, for joining us tonight on the program. Let's begin by getting clarity on the reason why the PDP has gone to the court on this matter.
Thank you, Sean. Good evening, Nigerians and viewers. Yesterday, the People's Democratic Party, the PDP, proceeded to court to seek certain answers to certain questions and also seek reliefs that are contained there in the originating summons. The suit in the main queries the continued stay in the office of Governor Buni of Yobe State, having regard to Section 183 of the Constitution, which makes it clear that one who is a governor of a state cannot take up any employment, paid employment, or go ahead to be the chairman of a political party. That is very clear. That provision is straightforward, it's unambiguous, and it seeks a declaration from the court that it was an illegal act. And if it's an illegal act, some result will come out of the illegal act because there must be a sanction for every illegality. And we're saying that one sure sanction is that he has ceased to be the governor of Yobe State. And secondly, that every activity, every action he ever took as the caretaker chairman while he remained the governor of Yobe State is null and void. That's our case. And like I've said earlier today, we are not here to canvass the merit or demerit of our case. We're just here to say, yes, this case exists. We filed it on behalf of PDP, and we stand by that suit.
What exactly are you seeking? Because this originating summons, for a lot of our viewers who may not understand the legal terminology, what is the spirit of originating summons? What does it hope to achieve? Is it an order of court that has been sought? Does it mean that the governor will appear? Is it an instrument that will remove the governor from office? Or will there be a substantive trial in this matter?
The originating summons is a procedure adopted by the courts of the land when issue of interpretation of a statute or constitution is involved, when there are no disputes as to facts relating to the case. It's more like a fast-track kind of a procedure. In this case, there's no need for any evidence from anybody to the effect that Buni has been a governor or has been operating in the governorship office of Yobe State. There's no need for such evidence. It speaks for itself. There's no evidence to show that he is the caretaker committee chairman of APC that is not there in the public realm. So what we have done is to bring those two issues together and then contrast it with the provisions of Section 183 of the Constitution of the Federal Republic of Nigeria. And then we ask the court to look at the issues at stake and know whether the PDP is right in saying that the governor, Buni, no longer should be in the office of the governor of Yobe State. So that's what it is. It's not like a statement of claim where you call somebody to come and lead evidence and you cross-examine, except the APC and the governor and the defendants come up to the court and say, no, Buni is not the governor of Yobe State, or Buni is not the caretaker committee chairman of APC. That's when there will be need for us to begin to take evidence and cross-examination. But in this case, the facts are straightforward. The law is there. It's just for the court to hear our case and hear the case of the defendants and come up to a decision whether the declarations we are seeking are correct in law or not. Of course, we know that you can never have an illegality go unpunished. And so there must be a punishment for the illegality that we have brought to the fore. But it's for the court to go ahead and know whether the case is meritorious or not. Don't forget that the matter is sub judice as at now, but we are just discussing on the periphery what the case is about. but not about the merit or going into the merit of the case.
It's interesting that this is coming up. And so, in essence, Mr. Etiaba, what the PDP is seeking is that, don't let me put words into your mouth. What exactly is PDP seeking?
PDP wants the court to confirm that Governor Buni has ceased to be governor of Yobe State de jure because of the activities that he has embarked on, to wit, being the caretaker committee chairman of APC. We are talking about having ceased. We're not telling the court to remove him. We're telling the court to confirm that. And when the court confirms that, the declaration will be made that he is no longer the governor of the state. We're also saying that by reason of the judgment in the case of Itayo Jegede versus Akerolu, both SAN, the Supreme Court decision that was delivered on the 28th day of July 2021, we're saying on the strength of that judgment alone, that Buni has ceased to be the governor of Yobe State. The only reason why Supreme Court did not descend on him is straightforward. You can read it, you can glean it from that judgment, because he wasn't a party in that appeal. If he was a party in that appeal, he would have left the government house a long time ago. And we're saying now PDP has come in line with that judgment, brought Buni before the court for him to now air his own defense. Tell Nigerians, tell the court why he thinks that he alone can be the governor of Yobe State and at the same time be the caretaker chairman of the APC. And this is a political party, don't forget, that has all it takes to run its national secretariat. And so this is what we call impunity at the highest level, that a governor in the office will double as the national chairman of a political party, not just for 1 year, but 1 year and counting. That is called impunity. And PDP has said that it cannot be tolerated anymore. This is a polity that must be cleansed. And PDP says it must be cleansed. Somebody alluded to the fact that PDP does not have enough interest in the matter. And my answer is very straightforward, because I'm not one that is given to playing to the gallery. PDP, the actions of Buni over the year has actually affected PDP in so many ways. The governorship election in Edo State, the governorship election in Ondo State, the governorship election that is going on now, the preparation is going on now in Anambra. Buni signed all the nomination papers. And so that affects PDP. Above that, we can give you reasons, more reasons why Buni should not be in the dual office and how it affects the PDP.
So you're saying that the PDP has a locus in this matter because this is an internal party matter, some lawyers will argue.
How can we say that it's an internal matter of the APC when you're talking about infraction of the drawn norm, the Constitution of the Federal Republic of Nigeria, that binds every Nigerian? In fact, the provisions of Section 183 of the Constitution, because of the seriousness that APC attaches to it, APC had to lift that same provision into its Constitution in Article 17, sub-Article 4. They actually domesticated this particular provision to show you that they are aware of what they are doing. How can they, after reading such provision in the Constitution, applying it into their Constitution, still go ahead? Is that not executive recklessness? Is it not? Can Nigerians sit back and say, why would this matter be in court? And I hear people talk in a very derogatory manner. But you see, well, the people have been impoverished, so they can air any view at any time. But some party like PDP says, thus far no more.
So there is an interesting scenario playing out. Should the court, I mean, this is a probability because the case has not been properly heard. Now, should the court say, Governor Buni, you can go home, PDP has a case, who will be the beneficiary of that judgment?
We in our release, we did canvass for the PDP to be the beneficiary. And if you're talking about the PDP, the candidates, But don't forget that even the Supreme Court of the land, the hallowed court of the land, has in several cases held that individuals do not go to election. It is a political party. In several cases, including Charles Odedo against INEC. That's a judgment of 2008. And so the mere fact that we have our candidates and we are saying they should go in does not mean that PDP doesn't have a choice, because PDP is the beneficiary. And if by any reason the governorship and the deputy governorship candidates of PDP are not available, then we will amend our process to talk about a fresh election. But obviously, our case is that it will inure to PDP that came second in that election.
So if you look at what is happening...
Please, don't forget that we are talking law here, and that the decision lies with the courts, not with the lawyers or parties. So I can make any contention that I feel free to make, but it is the courts that will determine what the reliefs will be. So
what is coming out of Yobe State today is that Ambassador Umar Ilia Damagum, who is a candidate of the PDP in the 2019 election, whom you say will be the beneficiary, has distanced himself from the suit instituted by your chamber on behalf of the PDP, and says that is not in any way demanding for the removal of Governor Buni. How would you react to that?
I will only say that it is his prerogative to associate with the case or distance himself from it. But I believe that PDP is a political party. PDP fielded him, and if he had any reason to distance himself from the case, he would have gone to PDP to air his view. But be that as it may, if he says it's not a part of it, all it will take is to amend the process and get his name off the suit. It does not whittle down the effect of the suit. It does not in any way prejudice the interest of PDP in the matter. So by the time he communicates to the PDP, my clients, that he's not interested, there will be a handshake, and PDP will instruct me to do the needful, which is to get his name and the name of his deputy off the suit, and the suit will go on. All this suit needs to go on is to have a plaintiff, and PDP is the plaintiff, for the reason that the two are not necessary parties, but parties, should be parties in the suit because it attaches to them. That's why their names came in. And so if they decide to go, we'll get their names out and still continue with the suit. But the suit cannot be frustrated because the governorship candidate and the deputy governorship candidate say they're not interested in the suit.
Mr. Tiaba, just give me a moment. Let me get, because this particular case is about the APC, and it does look like they may have some concern. Let me read out what the APC said in this respect to you. And they simply, there's a statement coming from the APC, and they've simply dismissed the position of the PDP. And this is what the APC said, and I quote, "While we are constrained from and reluctant to comment on the PDP's misplaced and frivolous court action because it will be sub judice, the PDP leadership is obviously executing a desperate and purely scripted propaganda plot aimed at deflecting attention from the crisis of confidence the failed opposition party faces. The PDP are ignoramus, rabble-rousers, and have no locus to take any action on the internal affairs of the APC. The Supreme Court has already affirmed the status and legality of the CECPC, and that is all there is to it." How do you react to that, Mr. Etiaba?
I'll simply say that my prayer is that when they are served our process, as a response to our suit, they should file what they have written and let the court give the judgment. Again, what you have read out is not addressed to me. I think it's political party to political party, and they are allowed to fight themselves in the social media and the electronic media and newspapers and all that. But as a lawyer, I expect their own lawyer to quickly accept the case and go to court and file whatever they think will make the case look like it is frivolous. It does not lie in the mouth of the secretary of the PDP, caretaker secretary of the APC, to determine whether a suit is frivolous or not. That's what we call impunity. That you have a serious case that threatens the life of the governorship of your chairman, and you have not consulted with your lawyers on your own from your armchair. You're telling the whole world that the case is frivolous. I hope they repeat it in court and see where it will land them.
All right. We, of course, have the lawyer of the APC here with us. He joins us from our Abuja studio. It's Mr. Shuaibu Arua. Thank you so much, Mr. Arua. Is your party in trouble, Mr. Arua, considering that for someone like Festus Keyamo, who in a private party to internal party circulated a memo saying that the party should be wary of what may become a floodgate of lawsuit. It was like a prophecy, and now it's happening. Not only the PDP, the new Nigeria People's Party has also filed an originating summons similar to what the PDP has filed. Have you received that originating summons, and how are your clients, the APC, receiving this?
Thank you for having me. Good evening, viewers. It appears that most of the people rushing to court on the basis of the Supreme Court judgment have not read the judgment. If they have read, I'm sure they wouldn't have gone to court at all. In fact, the Supreme Court judgment confirmed the legality of what the APC has done. The Supreme Court judgment confirmed that the APC is not in breach of any law of the Constitution by the appointment of Buni as the chairman, caretaker and extraordinary convention planning committee of the APC. Rather, the Supreme Court confirmed that it is within the powers and within the contemplation of the constitution of the APC to appoint the neck of APC, Article 13(3) of the APC Constitution, to appoint committees and vest such committee with powers, such powers it may think fit. So for people rushing to court, I do not want to comment directly on the matters that are already before the court. But for people rushing to court to file cases, I think most of those cases are dead on the arrival. They are dead, absolutely dead. We are talking about dealing with issues of abuse of court processes, and I think the judiciary would have to do something about it.
The basis of which people are challenging this matter is Section 183 of the Nigerian Constitution as amended. Let me read it out for our viewers to take note of it. Section 183 says, and I quote, "The governor shall not, during the period when he holds office, hold any other executive office or paid employment in any capacity whatsoever." Note, for student of law, the word "shall" has a very strong place in law. And I'd like Ms. Arua to react to that. When the law says "shall not," it means a lot, isn't it? And as it concerns Governor Buni, the dual role that he plays as the governor of Yobe State and as a caretaker chairman, a paying role, the caretaker chairman, the executive role is a paying role, is it? How do you react to that?
Sure. The Supreme Court has held that the position held by Buni, His Excellency Buni, as the chairman, caretaker, and extraordinary convention planning committee of the All Progressive Party is not an executive position. And it was clear in evidence before the tribunal, governorship election tribunal, that the position does not attract any emolument. For that reason, it's it was not, he was not holding an executive position.
No, I
as
didn't get...
contemplated by Section 183 of the Constitution.
The role of the chairman of the caretaker committee, are you saying that it's not an executive position? Also,
it's not an executive position. The Supreme Court held in the judgment, that is, the judgment between Jegede and Akeredolu, considered that and came to the conclusion that it's not an executive position. And I believe that all those people rushing to court to file one case or the other on the basis of that judgment, they have not actually read the judgment. They have not taken their time to read the judgment. The majority judgment, what most of them are concentrating on is the minority judgment. And for lawyers, we know the minority judgment of the Supreme Court is not a judgment of the Supreme Court. What we should concern ourselves is the majority decision of the Supreme Court, which is 46-page judgment. And most of these people, reading through some of the processes they have filed, will show clearly that they have not gone through the judgment, the majority judgment. For a reason best known to them, the litigants appear attracted to the minority decision, which is not the decision of the Supreme Court.
Mr. Arua, let's take a breather.
Yes.
Mr. Itaba is still with us, but we'll take a break. And when we return, we told you earlier that President Muhammadu Buhari is back in Nigeria. We might be getting more information on his next line of task as he returns into the country. Stay with us, everyone. We'll be right back, and we'll get back into our conversation on the APC leadership matter and the floodgates of legal tussle. Stay with us, everyone. We'll be right back. Let's get back to the conversation on the APC leadership matter. Mr. Emeka Etiaba is a lawyer to the PDP in this case, who has put up an originating summons to the Federal High Court saying that Governor Maimala Buni should cease to be governor, and the APC says that will not happen. Mr. Shuaib Arua is a lawyer to the APC and has been speaking to us. Let's get back to the conversation with him. So, where does your party go from here? They fear that there were going to be floodgates of court cases. Did you see that this was coming?
Yes, of course. It appears most people, like I said, most people are yet to read the majority judgment. And most of the people rushing to court are mere busybodies. They are not even members of APC. And one wonders, why are they going to court? What is their interest? And if they have read the judgment, the majority judgment, all these issues have been laid to rest by the majority judgment. The issues that the Ita Jegede's appeal failed because he did not join Governor Maimala Buni is just one of the legs of what the majority decision of the Supreme Court considered. The other is that the question as to the violation of Section 183 of the Constitution by Governor Maimala Buni was laid to rest in the judgment. The Supreme Court held emphatically that the position of chairman, caretaker, and extraordinary convention planning committee of the All Progressive Congress is not an executive position. It does not attract any salary, as contemplated by Section 183 of the Constitution of the Federal Republic of Nigeria. So, Governor Maimala Buni is not in violation of that provision.
So, if you look at, let me take you to the originating summons. From what you understand as a lawyer, the prayer of the PDP, how does this come to your principal, Governor Buni, on this originating summons?
I have not read it. I have not read it, but I'm aware how the originating process or originating summon can survive so many legal obstacles in our court. In the first place, the Federal High Court does not have jurisdiction to entertain that matter. Having regard to the provision of section 251 of the Constitution, subsection 1 of the Constitution. So I do not know how the Federal High Court will be able to entertain such a case that pertains to removal of a sitting governor.
I mean, you heard what Mr. Itiaba said, that the only saving grace for Governor Buni was that he was not joined in the matter between Mr. Itayo Jegede and Mr. Rotimi Akeredolu, both SAN, in the Ondo governorship case matter. And that's the reason why there were, I mean, he was able to escape that judgment and that he was not relieved of his job as a governor. But in this matter, that the PDP is executing...
Shehu, that is not true. That is not true. I have read the judgment. That is not true. That is not true. The judgment emphatically laid to rest the question whether Governor Mai Mala Buni, by accepting to serve as the chairman of the caretaker committee of APC, violated the provision of section 183 of the Constitution. And the majority judgment of the Supreme Court came to the conclusion that Governor Mai Mala Buni is not in violation of the provision of section 183 of the Constitution of the Federal Republic of Nigeria.
There are about 7 reliefs that the plaintiff is seeking here, and the lawyer to the PDP have reeled it out or spoken about it. And part of it is also the question on the minds of everyone is that a sitting governor has some level of immunity. Does the immunity cover Governor Buni in appearing in court on this matter?
That is what we are saying. There are so many legal obstacles that any action seeking to challenge Governor Buni will face. One of them is section 308 of the Constitution. The governor cannot be sued. Even the originating summon, whatever processes they have issued, is already dead on arrival by the provision of the Constitution, section 308 of the Constitution. They cannot move past that. Then secondly, we have to consider the tenure of office, section 180 of the Constitution. Can a governor be removed by instituting an action? I don't think that is correct. And I believe that all these frivolous cases going to court, our court, borders on abuse of judicial process. The only thing they are seeking to achieve is to harass APC for what of better things to do. If not, they should know better that these actions cannot survive. The issues being raised have been laid to rest by the majority decision of the Supreme Court. They are fixated. Most of the people rushing to court are fixated by the minority judgment. And we know what the minority judgment of the court is. It's not a judgment of the Supreme Court.
Okay. Let me ask this same question that I asked you to Mr. Itiaba on the position of the governor. He has immunity. Mr. Itiaba, can a sitting governor be sued based on what the Constitution says?
Well, thank you very much. For the past 20, 30 minutes, I've been listening to your guest, the lawyer to APC. And before I answer your question on immunity, it would be nice to tell you that I know this program as a very serious program. Nigerians watch between 7 and 8 o'clock every night. And to come here this evening to discuss the suit we filed yesterday, and the lawyer who is on the other side says that he has not read the suit. What is he arguing? What is the point coming here to discuss the matter with him? The matter we came here to discuss is not about the Supreme Court judgment that Supreme Court judgment, if he has read it and read our own suit, he will realize that we never cited the minority judgment. It never came to the fore. All the references we made to that judgment was the majority judgment. And all what he's saying are nowhere to be found in the judgment, majority judgment that he has been discussing. Don't forget that senior advocates in the APC have also given their own opinion, showing that there are landmines having regard to that judgment. The one he prefers to call majority judgment. I prefer to say that I know only one judgment, and that is the one that he calls majority judgment. And so if he goes back to read that judgment and goes back to contrast it with our suit and the references we made to that judgment, maybe he will begin to ask for a second bite at tonight's discussion. On the issue of immunity, you know, I told you that this matter is sub judice. But even at that, talking about immunity, that does not affect the case, and we have an answer to it. When we get to the river, we'll cross it. They are yet to respond to our suit. And remember, we are not to jump the gun. But I can tell you that it would be wishful thinking to think that immunity section 308 has anything to do with our suit. It does not have anything to do with our suit. And we can distinguish it. We can give you case law. We can give you the facts that would convince any court that immunity clause has nothing to do with the suit we have filed. With respect to the arguments proffered by my good friend, talking about the judgment and others, I can assure you that it is neither here nor there. And you cannot call me and say, Emeka Etiaba, Emeka Etiaba. I can say I'm not Emeka Etiaba. It's my word against yours. How can he come here and keep telling you that the judgment says this, the judgment says that? If I knew that this is about the judgment, I would have come with that judgment, and I'll read out the portions of that judgment that run totally in contradicts whatever he has told you tonight. Be that as it may, Sheung, I can tell you that APC has a lot in their hands with respect to our suit.
Just on a final note, Mr. Etiaba, if this court case goes through, it does look like an exercise that will be academically relevant, one, and also it will be a landmark, whichever way it goes, I suspect. Is that one of your aim, not only to achieve your prayers or to get your prayers, but also to make a difference in law? Is that part of it?
So you're getting it a bit wrong. Saying that a suit is academic means that it is of no value.
No, I'm saying that it will have... what I'm saying is that...
Maybe it is novel, that you want to use the word novel. Yes, could be said to be novel, but not academic. If it was academic, then the court will not entertain it. Academics is what I have said you have embarked on tonight, calling somebody who has not read it, the court process to discuss it. You know, so if it goes through, and indeed it will go through, I can assure you that impunity will be caught by some fraction, because the declarations we are seeking are very, very apt. Number one, we are saying that the court should hold that what Buni has done is an infraction of Section 183. We are saying that by reason of the judgment in Jegede and Akeredolu, that he has ceased to be a governor. These are not academic. These are real issues that will touch on everything that we're talking about. We are saying that if there's an infraction to 183, it will come with a sanction. And we're saying the sanction includes that every action he ever took as the national chairman of APC will be null and void. Remember that you cannot put something on nothing and expect it to stand. That's McFoy against UAC. And so for every action he ever took, it will become a nullity, and that will be far-reaching. And that is where the party should be looking at. Let the party not be talking about what color of shirt Etiaba is wearing, who wants the case and who doesn't want the case. Let the party look at the questions. Let the party look at the reliefs. I can assure you that the people I know are APC lawyers cannot come here and tell you the case is frivolous. When you said lawyers from APC were coming, I was expecting the people I meet in battle at the Supreme Court, at the High Court, at the election tribunals. And then if they are here and they're looking at my suit and they say it is frivolous, I'll say thank you, we'll meet in court.
All right.
Thank you.
Thank you so much, Mr. Etiaba. Let me get your final word, Mr. Arua. We're due to close in just about 60 seconds. What's your final thought on this?
Yes, with due respect to the learned silk, even if I have not read the processes he's filed, I can tell you, and mark my word, that the suit is dead on arrival because there are so many legal obstacles that confronting this suit. And I believe that for anybody to rush to court and file this kind of claim, the person is yet to read the 46-page lead judgment of the Supreme Court. All these issues were taken up by the Supreme Court, dealt with, and laid to rest. So people are just excited about the minority judgment. And they should leave that alone. They should concentrate on the majority judgment, which indeed has validated the position of the caretaker committee of the APC. It has actually given a legal backing to the caretaker committee.
Mr. Shuaib Arua, lawyer to the APC, thank you so much for your time. And Mr. Emeka Etiaba, senior advocate of Nigeria, I appreciate your time also. Thank you so much for talking to us. Well, that's our show for today, everyone. Many thanks for watching. I'm Sean Akimale. Bye for now.